Hi, everyone. Welcome back. I'm Kathleen Scott at the Scott Wagner Law Firm. This is a question and answer session to answer your most burning questions about COVID-19 and employment law. I know there's a lot of people out there who have questions about being laid off or furloughed, what those terms mean. So this is my opportunity to answer those questions for you. One that I'm getting a lot, it is a question, thank you so much for sending it in, about I don't feel safe in the workplace. I don't want to come into the workplace anymore, and my employer does not have an opportunity for me to work remotely. What are my rights? So in answer to that question, it is very much, it depends. If you work for an essential employer, like a healthcare provider, a grocery store, the Amazons, that type of thing, then your company can require that you come into work. That doesn't mean they can force you to come into work. Everyone has a choice. So here I'm coming to you live from the state of Florida. If you choose to not come to work and you're a Florida resident, then the question becomes, do you have a claim against the employer? And the answer is probably not. You have a choice to make. If you're not able to come into work because the employer isn't able to offer you appropriate protective equipment, or what we call PPE, and you hear that term a lot in the news lately, and it's because the employer has it but won't give it to you, or is not following the proper OSHA rules, then you may have a different issue. And so in that scenario, you should, in a nice way, let your employer know that you're concerned that you don't have sufficient PPE, and then have a dialogue, engage in a process with the employer to talk about how best to get that equipment before you make the rash decision to either quit or not show up for work. If your employer retaliates against you, takes you off the schedule or anything like that, then that might be a source of a retaliation claim. So if you don't feel safe going to work, we get it. First step is to have an open communication dialogue with your employer to find out what they can do to address your safety concerns. Another idea would be, well, can the employer offer to you some type of remote work? So that could be a reasonable accommodation. It's particularly a reasonable accommodation in a situation where if you yourself are immunocompromised, or you live with someone who's immunocompromised, and then asking for remote work is a great way to keep the business going and also keep you safe and keep you away from infections if you have a healthcare condition that requires that. That's not just a good idea, it's likely required under the Americans with Disability as a form of an accommodation. So good question, and thanks for asking. Our next question is, when do I qualify for unemployment compensation rights, and how much will I get? Great question. So unemployment compensation is available to anyone who's not working, or is what we call underemployed. So maybe your hours were significantly reduced. And in that scenario, you might be eligible for unemployment compensation. Under the stimulus bill that just passed, you will be able to get an additional $600 of what your state normally pays. So Florida, it pays $275 right now, and that amount will increase up to $875 for those who qualify. So the second part of that question is, when do I qualify for unemployment compensation? And the answer is, if you've been laid off or your hours have been significantly reduced, we call that underemployed, and you can be terminated for reasons related to COVID-19, or simply just because there are some questions about whether you are able to continue working. If your business goes out of business, the company that you work for goes out of business, that's another great way to, another good reason to get unemployment compensation. And so next question that the writer is writing here, it says, if I'm unable to work, can I get paid family leave? These are all really good questions. So Family Medical Leave Act was expanded last Wednesday afternoon, and it applies to all businesses that have less than 500 employees. That's a lot of businesses. Now, healthcare providers have been exempt under the law. It's not an automatic exemption. They have to tell the employees that they're exempting themselves from the law. And so if you work for an employer that has 500 or less employees, and there's one qualifying reason that you get for FMLA, the extended FMLA, is if you have to stay home because your son or daughter's school has closed because of COVID-19, or daycare is closed, or your compensated child care provider is no longer able to continue to offer child care services because of COVID-19. If that's you and you are unable to work because of that one scenario, the schools are closed, daycare is closed, or your healthcare or your child care provider is unable to work, then you could qualify for paid family leave. What does that look like? It's up to $200 a day for as long as 10 weeks, to a cap of $10,000. So small businesses would have to pay that family leave in that scenario. And so this is obviously going to affect a lot of businesses. If your company is out of work, or out of business, I should say, they have closed, then there is no obligation to pay the family leave. I should also mention, sort of in conjunction with the paid family leave, that last Wednesday, President Trump signed into law a mandatory sick leave bill as well. And so what that requires is for all employers, again, less than 500 employees. So this is pretty much every business out there, except for the big ones like Amazon. So this is every business out there has to give full 80 hours to full-time employees of paid sick time. And there are scenarios in which you get the paid sick time. That is if you are quarantined because of a state or local government order, if you are being told to self-isolate because of a healthcare provider has recommended that to you, that you yourself are symptomatic and you're seeking a physician's review of your symptoms, if you're taking care of someone in either the first or second category, or you yourself are sick. So in those scenarios, you would be entitled to up to 80 hours of paid leave. I should also mention that the FMLA portion that we spoke about first, that's the 10 weeks of paid family leave. The enforcement mechanism for that is the Department of Labor. For businesses, that's a pretty scary entity to come after you, right? That is like inviting the fox into the wolves, and rather into the den, right? So we want to avoid any type of compliance issues on behalf of employers. The sick leave pay, if there's a violation of the 80-hour sick leave pay, then that statute actually allows for private rights of action to be sued. And it's an amendment to something called the overtime lawsuit, which just means sort of plainly that if your employer were to violate the Sick Pay Act, they would be on the hook not only for back wages, but something called double damages or liquidated damages, as well as attorney's fees and costs. So I say that to all the employers out there that are listening. This is something that you really need to be aware of. Healthcare providers are exempt under both family leave and for sick pay, as well as emergency responders. That's pursuant to the DOL's guidelines. I believe that came out yesterday morning. Things are happening quickly, so we do have some clear guidance on that. So that's a great question. Thank you so much for asking it. Let's see, I think I have a couple more here I want to address. Who's going to pay for this? That's a good question. So who's going to pay for this? So this is how it works. So if you're an employer and you've just found out either by listening to me or been reading the news that you now have to pay for up to 80 hours of paid sick time if you keep your practice or business open, and you have to offer up to 10 weeks of paid family leave, you might be wondering, how can I afford that at a time my business is taking a hit financially? Well, the good news is it's a tax credit, and it's more than just a tax credit. We initially thought that you would only get back the money when you filed your 941 reports, which are quarterly filings. But now we know from guidance that came out yesterday, we know that you can apply for that tax credit pretty much instantaneously. So the next time you have payroll, you get the credit for your payroll taxes. So it is coming from the government, although it's being fronted by the individual employer. And so that's who's going to pay for it. Let me just go ahead and turn my head here and address a couple of more questions that just came in. This individual asked about, he was just terminated and is upset because he had accrued vacation time and he didn't get the vacation time paid out, and he wants to know if he can bring a claim for that. Good question. So in order to get your vacation, or what we call PTO or paid time off, that is only payable if the company has a policy that says it's payable. It also bears mentioning that vacation time and PTO is completely separate from the employer's obligation to pay these 80 hours under the Sick Act that was just passed, the Paid Sick Leave Act that was just passed. So let me say that again. The employer cannot use any accrued time that an employee has in order to offset the 80 hours that they're obligated to pay that employee as a result of this new bill, the Sick Leave Act. So please be aware of that. Keep that in mind. Those are not offset. What we're seeing a lot of, and it's from our view, it's perfectly legal, is employers saying to their employees, look, moving forward, we're going to comply with the federal law, and therefore we're going to suspend all benefits. And that's prudent, because I think in this climate, employers are trying to do all that they can to keep the doors open, right? And so that's perfectly appropriate. So this one's asking me, what if I can stay home and collect unemployment, which is as much as I make? How does that work? I think I addressed that a little bit earlier, but let me just go through it again quickly. Unemployment is an option for anyone who's either underemployed or out of work. If you're still gainfully employed, you're not able to get unemployment compensation, but it certainly bears mentioning, having a conversation with your employer about that. So let's see. One other question here is, what if I'm in an essential business and I'm coming into work? What are the employer's obligations? Okay, so if you're an essential business, and you need to look at all laws. So I know we have a nationwide practice. So depending on where you're joining us from, you need to take a look at what the governor in your state has done. I know in Florida here, the governor has closed some businesses, not all, and they have defined it based on essential versus non-essential businesses. So if you're working for an essential business and they're able to keep the doors open, they can ask you to come into the workplace. They should practice two things. PPE, they should supply you with sufficient equipment if you're dealing with the public to make sure that you're protected. They should also practice social distancing. So for example, in my law firm, we have our larger staff. We're almost all working remotely. I'm joining you here from my home office, but we do have individuals in the office, but we have a rule of two. And so there's only one person in the front desk and one kind of in the back, and they're staying socially distanced away from each other. For an essential business, that works. If you are a non-essential business, then you are not allowed to be open to the public. That doesn't mean that the company can't function, doesn't mean that they can't earn revenue. It just means that they need to figure out a way to work remotely. For those of you who are new to remote work, or employers who are wondering, I'm not ever allowed remote working, why do I have to now? Let me offer you a couple of suggestions. One is, if you can offer remote work, then you no longer have to, if you're an employer and you offer remote work, then you don't have to worry about complying with that sick leave law or the family leave law, because your employees are working and your business is flowing. So that's a good thing, right? If you're not able to keep remote workers, then you either might have to lay off the employee, in which case they might apply for unemployment compensation. There's a couple of caveats with remote work. You need to make sure that you have security, right? And so let's talk about some of those issues. If an employee has their own laptop at home, they may just feel like they can log into the company's workplace and that's all good and well. And it might be, but you as the employer need to make sure that they're logging in through a secure connection, because that's going to be very important to maintain the integrity of the company data. Another issue that comes up with remote workers that's worth getting ahead of is figuring out the hours of the day that person's going to be online and how they're going to maintain staying in touch with their workplace, right? So you don't want to be working remotely as opening a door for an employee to work a bunch of extra hours and a ton more of overtime hours. So overtime is defined as working more than a 40-hour work week, or in certain states like California, over an 8-hour day. So you want to make sure that you're complying with those particular wage and hour laws. So this is all about communication. It simply comes down to being able to sit down with your employer and employees to have a conversation about, what's going to work for us. And you can really be creative, particularly in the state of Florida, where you can say, we can only give you 5 to 10 hours a week, and then the employee can decide that works for them, and they can make up the extra time by going to the unemployment office, or they may decide, you know what, my kids are out of school and they're home and it's just, I can't be productive here in the house. And if that's their reality, they need to be honest about it. And then they too could qualify either for sick leave and or unemployment compensation in these scenarios. Unemployment right now is more robust than we've ever seen, pretty much in anyone's lifetime. I know I've been practicing 21 years. I've never seen unemployment as a comprehensive benefit as it is right now. So unemployment compensation right now, there's no waiting periods. The standards for how you can get it and what the qualifying reasons are more relaxed than they've ever been. And they've relaxed the obligation that the employee has to look for work right now during this COVID-19 crisis. The federal government's thinking, based on the notes of the statute, is they want people to stay home. And so they're incentivizing employers and employees to get people to stay home. So if there's no remote work available, employees can certainly claim that unemployment compensation benefit. Make sure you pack your patience, because the unemployment compensation office in the state of Florida, which is floridajobs.org, that website is overwhelmed with new filings. So you may want to get up early in the morning and try to do it first thing. It's a 2-step process, and I think last I heard they're trying to reduce that process. It's a online registration and then a phone call, and so people are having very difficult times getting through to the phone call. If you're having trouble, there's really no advice other than to say keep trying. And we hope that that's helpful information for you. I'm just going to turn my head here and see if there's some other questions coming in. All right. So this employer is asking, they're doing a layoff, what written obligations do they have to the employees? So that's okay. So if you're an employer and you're made the decision that you're going to let some people go for this reason due to COVID-19, you should just tell them that's the reason. You don't have an obligation to do anything in writing to them per se, and there is no law in Florida that requires the payment of severance pay. So that's two important things to know. Severance is considered to be a gift under the law. You're not obligated to pay any paid time off unless you've made a promise to that employee that you're going to do that, and that promise usually exists in your handbook, so I would consult your policies. You do, however, have an obligation to the employee to tell them that they're entitled to unemployment compensation and to direct them to that website to get that information that they need. So that is the floridajob.org's website that employers need to know about that. All right, let's take a look. And I think I just have a couple more here. So if there's anybody out there who wants to have more questions, I got one coming in right now. Thank you so much. It says, for the new Paycheck Act, can employers get relief for employees making over $100,000? I'm a commissioned employee with a salary. Can my employer stop paying my salary but still expect me to work? That's a good question. So the Paycheck Relief Act, we're getting ready to do a webinar on that particular issue, and we're still dissecting all of that, but my initial understanding is, no, I don't believe so. If you make over $100,000, that is not the case. So, but thank you for the question, and stay tuned on that. We're going to make sure that we get all of those loans. We're going to do a special seminar just on loans, grants, and information that's out there for the Paycheck Relief Act. Okay, so there's a question now from an individual who's saying that their company is making them use all their paid time off in order to get through this crisis, and they want to know, is that allowed? So yes, your employer can ask that you use your accrued time off if you're not working during this time, but keep in mind, if you qualify for family leave or sick leave. So let's go through that analysis. So if you're working for someone and you can't work because you have to stay home because your child's school is closed, then you qualify for family leave. And that means that you get the first 10 days for free, and you can choose to use your paid time off for those first 10 days. And then you get up to 10 weeks thereafter at $200 a week or $10,000 in aggregate. So that employee in that scenario would have a potential claim against the employer. If you're not able to work because either you're sick or you have to stay home because you're self-quarantined or you're being ordered to quarantine because of a governor order, in that scenario, you'd be eligible for the sick time. And so the sick time is up to 80 hours, and that's payable at $510 a day to an aggregate as much as $5,110 for that particular employee. So employers beware, those are expensive things, but they're things that you're going to have to deal with, and you get all of that back in terms of a tax credit when you go to do your payroll, the next payroll that you run. Another question, thank you to my good friend, Charlotte Frenaye Kelly, who's just updated me that another great employment lawyer, anyone out there in her area, she's excellent. She's let me know now through Facebook that they've updated the website for people who have reduced hours. So it now allows you to keep applying. So that's great news. Thank you, Charlotte, for that update. So you're allowed now, because there was some difficulty getting people to apply who had underemployment claims, they still had a job, just their hours were reduced. So now the unemployment office has fixed that problem. So that's great to hear. I'm going to take another quick thing to see if we have any other questions out there. Okay. Someone asked a question yesterday that I'm going to repeat the answer because I think it's worth knowing. One is, can I post on Facebook that I'm upset about the way my company is treating me during the COVID-19 crisis? And so Facebook posting can be, you do have a First Amendment right to post if you're a private employee. Public employees have a little bit more limitations. So if you're a private employee, be careful because if you have an issue with your work, the best way to handle that is usually go to your supervisor, to the chain of command, or if possible, human resources. That's how you address the issue. Once you've rung the bell and gone to social media and publicized your employment issue, understandably, that's going to make it a little bit more difficult. And while you have a right to do that, ironically, and anyone that likes your post may also be engaged in what we call concerted protected activity. They may have claims if they get retaliated against. What I would say to you is, yes, you could have a potential claim. That's a good question. But at the same time, in this day and age, it might be as important, if not more important, to have a job versus a lawsuit. So I might suggest that you take a less drastic approach by first trying to work it out with your company before taking it to the court of public opinion, because it really kind of could hurt everyone. All right, well, thank you everyone for joining us. If you have any other questions, I'll stay on just another moment here, and I'll ask my assistant here if there's any other questions. It looks like there's not. Thank you, Dylan. Okay, and so we are good to go. Thanks, everybody. Stay well out there. We'll be back again same time tomorrow. Talk to you soon. This is Kathleen Scott from Scott Wagner. Feel free to call or email us or Facebook Messenger us. Thank you.